The U.S. Supreme Court ruled today that some business owners who oppose birth control on religious grounds do not have to provide their employees with insurance coverage for contraceptives. Joining me to discuss the ruling are Professor Glenn Smith, a constitutional law expert at California Western School of Law, and his colleague, Professor Susan Chanik, co-director of the school's Institute for Health Law Studies. Professor Chanik, let's start with you. In this case, two family-owned businesses said the contraception coverage requirement ran counter to their religious beliefs. In this ruling, is the Supreme Court, in effect, putting their religious rights over a law that promises women insurance coverage for contraception?
I guess at first glance it certainly appears that way, and this has certainly been sort of promoted as a case of, the conflict of religion and women's rights. But in truth, women are still going to get contraception coverage. It won't be paid for. It might not actually be handled by the corporation, but they are going to get contraception coverage. And I think that was one of the basic tenets of this decision, is that there already is an accommodation in place for nonprofits, religious nonprofits, that were objecting in the same way as Hobby Lobby and Conestoga. And I think the court believes that that accommodation will suffice to make sure that women have the right to contraception coverage without payment on their own.
Professor Smith, this was a 5-4 split decision.
Yes.
In her dissenting opinion, Justice Ruth Ginsburg said that the ruling means commercial enterprises can opt out of any law, barring tax laws, they judge incompatible with their sincerely held religious beliefs. Do you agree?
Well, I agree that that's the ultimate risk here. Whether or not that's true depends on a balancing of rights. Deciding that, as the court did, that corporations and for-profit entities have religious freedom rights simply allows them to assert that their rights are important enough to countermand the requirement of federal law. But that's in each case, you have to weigh the strength of the government's interest versus the strength of the religious interest. And so a very different weighing might happen in the future.
Professor Chanik, the majority opinion stated that, look, if the federal government wants to, it could choose to pay for contraception coverage, removing these private companies out of the equation. Is that a viable option?
I think that there's actually, as I was talking about before, an accommodation that comes before the federal government paying, and that is that the burden of paying is going to be shifted to the insurer, to the company's insurer. But if that doesn't work, and the majority opinion relied on the fact that that might not work, they said, well, then the government can pay for it. And I suppose in theory the government could pay for it, but Glenn and I were just talking about how is that actually going to happen? Is Congress actually going to step in and make that happen?
And might you then have the same fight?
And you might exactly have that. I mean, you might have a fight about that as well. I think you very likely are going to have a fight about that as well. So how exactly the government would pay for it? I mean, theoretically, the government certainly could pay for it, and I think the government is probably ready to pay for it. But how easy that it's going to be to implement is another story.
Professor Smith, lawyers for the administration said that, look, private companies have never been accorded rights based on religion. Why didn't that argument hold any water with the justices?
Well, it was a combination of arguments. They looked at the fact that the federal religious freedom law used the word person, a very broad term. They looked at Congress's intent to broadly protect religious freedom, and they read a very disputed precedent. They read it, it's an old and disputed precedent, they read it broadly to protect religious freedom. I think there was a bit of an agenda here by the majority to try to reach this point. It's a plausible argument they made, but I certainly think that when Congress almost unanimously passed this Religious Freedom Restoration Act, they were thinking of individual religious people exercising their religious freedoms through churches, nonprofit churches. They weren't thinking of 17,000 employee for-profit religious, corporations exercising these rights. So I think the dissent should have. I would have been with the dissent, but that's when you have a divided Supreme Court, 5 justices can go the other way. You can have the best argument in the world, but unless you can get 5 justices, it doesn't matter.
Professor Chanik, is this a blow to President Obama's health care law?
It's not a blow in the actual implementation. That is, this is going, this contraception mandate is going to be implemented one way or the other. But I suppose it's a blow to the administration and really to Congress as well. That is, this is a broad kind of health care prevention program, and this is really an intervention. This is really demonstrates the ability of individual corporations or persons or whomever to challenge the law that was intended to be generally upheld.
And we're going to wrap it up there. We've got more on this discussion online. Professor Smith, Professor Chanik, thanks very much for coming on the program.
Thank you, Amanda.
Thank you.